welcome to The Presumption, a podcast with Jim Griffin, me, and Matt Fondelier. Hi, guys.
Hey.
Hey, Sarah. How are you?
Good. How are you?
I'm doing great. Thanks.
All right. So, look, we committed to talking about Kohberger as things come up in that case, the Idaho 4 slayings of the 4 university students. And there's some more BS that came up that I think we need to talk about to kind of unpack and demystify. And so, Jim, the first thing that the prosecution filed new pleadings in response to the defense. There's this ongoing battle over the DNA having to do with the IgG and the DNA on the knife sheath. Right. And the prosecution is alluding that the defense has a theory that Kohberger's DNA on the sheath was planted. They never use the word planted. They've never accused the prosecution of any sort of nefarious wrongdoing. And that the FBI family tree has no relevance whatsoever to that theory. So therefore, it's not material to the defense. The prosecution is claiming that the defense is saying that the people who did the DNA testing were biased. Even if the defense wants to go down that road, which it doesn't seem so, and claim that process was rigged. They literally use the word rigged, that the FBI family tree has no relevance because it only led to a tip and we're not going to use it at trial. So you're not going to get it. So it seems to me like they're writing their motions for public consumption. Like it's all hyperbole, right?
Right. I was going to say the same thing. They're playing to the press now.
They're playing to the press. And so it's not that they're not arguing, the defense is not arguing it's planted. They're saying it's touch DNA. So what's your reaction to touch DNA, the idea that it can be transferred?
Well, I mean, it can be, and we know that. I mean, there's so much. Well, first, we've talked about this before. The fact that they found single source DNA, which they apparently now traced back as close as they mathematically can to Bryan Kohberger on the snap, that doesn't mean that he was at the crime scene. So we know that. And there are other ways that you can cross-contaminate DNA. I mean, it is touch DNA, and it could come off some other item that had his DNA on it. Could have come from, it all depends on what lab was used, what else was in the lab. Was his DNA in the lab? Was there contamination in the lab? I mean, all that could happen by accident in the lab. I mean, it could be intentionally planted in the lab. The defense is not saying one or the other. They're just saying, we can't accept this as gospel until we're able to examine it with our own.
And the issue of whether the prosecution intends to use it at trial is really not the point right now. The point right now is that it could be exculpatory and therefore material. And also, the defense has never said that the DNA is planted on the sheath. Defense has said that the DNA could be put on the K-bar sheath by someone other than Kohberger. It's a big difference, right? That it could be transferred. There were hundreds of members of law enforcement and one unnamed lab that the state refuses to name. Like you said, we don't know who did the testing. The IgG process was like a lineup, right? Where the government knew who they wanted to target, even though there were 3 additional male DNA profiles that were found in and around the scene. We can't forget about that. That is a big deal. Why or how they came to believe that the suspect's car was, Kohberger drove is still unknown. So, and that's how they linked him, right? And so the defense essentially is sitting there having to guess whether the prosecution focused the investigation via a tree experiment or via the faulty ID of the vehicle involved in the case, meaning that there was the wrong year on the car and then they corrected the year. So all the defense is saying is we need to know, and therefore we need the IgG materials. We need this family tree materials. The correlation between the identification of the car, Jim, and the tip that was generated by the FBI family tree has yet to be explained in the discovery. So why is it Kohberger? And then to use the word rigged is just hyperbole And I think it's disingenuous because it's an incomplete story. So they're just saying we don't have enough and we need more. That's all they're saying.
That's right. And what the prosecution is doing is filing something saying, how dare the defense lawyers accuse these dedicated law enforcement officers of being crooked.
Right.
I got to tell you, cops plant evidence all the time. I mean,
it's certainly a possibility, even though they don't know yet.
We had a high profile case where a police officer in South Carolina shot and killed someone who was fleeing from a traffic stop, and he threw down his taser by the body, and he was going to argue it was in self-defense. Yet he didn't know that there was someone with a video camera on their phone to capture the whole thing. So, that was a huge case. That was of national significance here. So, cops do plant evidence. I mean, let's don't say they don't. But
sure they do. But the defense is not even saying they did.
That's right.
Not their argument, right?
That's right.
And so that, like you said, I think the prosecution is playing to the media. It's playing to the sensationalism that has been a problem in this case. Now we get to the issue of time waiver, Jim, right? So the time within which by statute a defendant has a right to exercise their speedy trial right, essentially going to trial in a speedy fashion, which you exercised for Murdaugh in South Carolina, is a very sacred right. And so when we waive time, we're opening up, we're going down this rabbit hole of continuing the case. In Idaho, a defendant has a right to speedy trial within 6 months of their arraignment unless they waive time. Kohberger has not waived time. Instead, what they've done is they've essentially told the time, they've stayed that time, and the prosecution is kicking and screaming over that. The way, Jim, that the defense has done that is based on the grand jury materials. Right. They said that we might contest the grand jury presentation proceedings and the indictment, and therefore we don't want to waive time. We want to put this on hold, essentially ask for a stay temporarily until we get those materials and determine whether we're contesting the indictment or not. Right, get it dismissed. And the prosecution is saying, wah, they just don't want to waive time. And this is bad precedent. And they're getting freebies instead of getting a time waiver. If you represented Kohberger, what would be your response to this?
Stop whining, prosecution, but it's a legitimate request. They did get a stay, it's temporary stay. They need to get the transcripts, but the defense is keeping the pressure on the prosecution. And do they have everything that and are they ready to go to trial in 6 months? That's the real question. Usually it doesn't. Usually defendants do waive. Most of my cases in federal court, we are always waiving speedy trial.
Of course,
I've never in federal court with all the resources of the United States of America, bore down on your client. I've never felt like it's to my advantage to rush the FBI to trial. Now,
it's very rare that we exercise a speedy right to trial, and it's really in situations where we know they have nothing, like you did in Murdaugh, and you go, let's go today, But you got to be really certain of that. And here, listen, I get the prosecution's argument. They're saying we need to rely on a set trial date. We can't have this wishy-washy thing because we need to coordinate our motions, prep our witnesses, secure their testimony, make sure law enforcement is available to testify, cops take vacations, etc. But they're just arguing to argue at the end of the day because it's just 6 months and 37 days, right? It's not like a whole lot of time. The prosecution is not being prejudiced really here. So anyway, the last thing, well, Jim, I think you want to talk about the alibi. We record these podcasts. It's not, a news show, so we're not in real time. But today is the deadline by which Bryan Kohberger would have to file a notice of alibi if, in fact, he plans on presenting an alibi. And it's late in the day, and he has not done so. Big deal, Jim?
It's interesting development if he doesn't do so by the end of the day, but he's not obligated to put up an alibi defense. And, people shouldn't lose sight of the fact that it's the state's burden to prove he was there at the date and time the murders were committed. It's not his burden to prove he was not there. And so, so
he could be acquitted or convicted with or without an alibi.
No question about it.
Right.
No question about it.
All right. So the last thing I want to talk about is there's a new case that has made headlines, which is the Rex Heuermann case, the Long Island serial killer, who went into custody, got arrested last week. And people now, speaking of sensationalism, are putting side-by-side photos. Matt, do we have the photograph of, okay. I mean, these dudes, they're both nerdy AF, but they don't even look alike, right? But people are going, what do you think? Oh my God, there's something in the eyes. That, Kohberger slayed 4 people. This guy raped and murdered and buried the bodies of, 4 sex workers, 4 and 4, the eyes. Yeah. I mean, it's driving me insane because we know, first of all, the biggest distinction, I think, in Heuermann, Jim, is that he had confirmed contact with the victims. The state has confirmed contact with the victims. We know of 0 contact between Kohberger and the 4 Idaho students, right? That's
correct. And there's been a push to demonize Kohberger. I mean, early on there were questions as to, is he linked to other unsolved murders in the area? And now, they're lining up his photo next to someone who, apparently, is charged with being a serial murderer. But, that guy's presumed innocent too. So I'm not jumping.
Well, yeah, but let's talk about the DNA, right? We've been talking about DNA. Sure. The DNA in Kohberger is touch DNA on a knife sheath, right? We've talked about that ad nauseum. The DNA in Heuermann is his hair and his wife's hair was found in the burlaps or on the bodies of a couple of these victims, right? And it matched. He wasn't in the system. He wasn't in CODIS, but they matched it to his DNA from a pizza crust. Essentially, they were following him around because they identified him through potentially his car, the type of car that was found near where these victims were last seen. And then as they had him under surveillance, they follow him around. He throws out the pizza box with crust in it. It was pretty damn impressive what the law enforcement did here.
Right.
They take his DNA from the pizza crust and boom, it matches, the hair in with these bodies. So this is way different DNA than the touch DNA on the knife sheath, right?
They should also this is what we should be publicizing to scare off criminals. Enough of this. You're going to serve 20 years, blah, blah, blah. What we should be saying is if you commit a crime, you will not be allowed to order a pizza, because if you order a pizza, we will find you. And I'm telling you, crime is going to go down. People love pizza.
I mean, this was New York. It must have been good pizza.
Yeah.
If Domino's will get you in trouble or not. But look, Heuermann, Jim, had burner phones, and he had used those burner phones to call the victims' families and essentially taunt them after the murders. And those burner phones were traced to his office location. The amount of evidence in Heuermann, yes, he's presumed innocent in a court of law, but I'm not going to lie to you. The amount of evidence in that case is absolutely overwhelming. I believe there's going to be more bodies tied to him. And we're nowhere near that evidence land that we are in Kohberger.
No, and we'll never will be, obviously. I mean, we would have heard more if there was more, because we're hearing every little tidbit they have. They're not holding back. So,
yeah. And I think the reality is that they're both accused murderers. And that really is the only thing they have in common right now. That's all I can say about the two of them. If we're going to sit there and compare apples and oranges.
I'm with you 100%.
All right. Well, we're going to take a brief break, and we're going to come back with Jennifer Bonjean, who's going to talk to us about the racket called the Me Too movement, and the latest in that racket, which is these look back window laws. So stay with us and we'll be right back. Hello and welcome back to The Presumption with me, Jim, and Matt. And today I am joined by a dear friend of mine and colleague, Jennifer Bonjean. Welcome, Jennifer.
Hello, Sarah. Hello, Jim. Hello, Matt. Hi.
Hey, Jennifer.
Hey, welcome.
So Jennifer, there's so much to say about her. I mean, but I'm going to get into some tattoos later. But Jennifer is the founder of Bonjean Law Group. She is a seasoned criminal defense and civil rights litigator who specializes in appellate post-conviction and habeas corpus litigation. Her passion and tenacity drive her to aggressively fight for individuals who have been wronged by the criminal justice system, as she works tirelessly to reverse the convictions of innocent people who are wrongly incarcerated. She's committed to exposing the rampant police and prosecutorial misconduct that often leads to wrongful convictions. In 2014, the Chicago Innocence Project awarded Jenny the Humanitarian of the Year award for her work on the Stanley Rice appeal. But Jenny is most known for her work on Bill Cosby's appeal, which all of you, I'm sure, were following. And oh God,
This guy?
that's cute.
That's too much.
Yeah, I mean, look, Bill Cosby was the Jell-O pudding guy. He was America's dad. He was, he had a legacy, and all of that was impacted significantly, unfortunately, by a bandwagon of women from coast to coast who have come forward, who are still coming forward, who will come forward even when he's in his grave, about, sexual abuse allegations. So because of Jenny's stellar work before the Pennsylvania Supreme Court, Cosby's conviction was overturned in June 2021, the court finding that his due process rights were violated when a non-prosecution agreement with a previous prosecutor meant that Cosby should not have been charged in the first place. But it seems like Cosby is convicted in the court of public opinion and will deal with civil lawsuits over sexual assault allegations all the way, like I said, to his grave and in another life. Jim obviously is new to your work, Jenny.
Yeah, Jenny, congratulations on that work in the Court of Appeals. What claims are Bill Cosby currently facing? Is any criminal claims, or are they all civil?
No, he has no pending criminal cases. And as far as I can see, although there do seem to be new allegations every day, frankly, he is not in jeopardy at this point criminally. Most of the allegations are quite old. I think the most recent allegation was the allegation that was prosecuted in Pennsylvania in Montgomery County, and the one that he was ultimately exonerated of. I'm not familiar with any allegations that post-date that, and any that predate that are for the most part going to be barred by criminal statutes of limitations. And then, obviously the ex post facto clause prevents the states from reviving statutes of limitations, although they would certainly like to. I think California tried at one point, but the U.S. Supreme Court said no.
Wait, so the alleged victim in the Pennsylvania case that should not have been prosecuted that you reversed, that person's coming forward in another? I thought there was a civil lawsuit with her back in the day.
Her civil lawsuit predated the criminal case. Okay. In fact, there was a civil suit that settled.
Right.
But what I was saying, Sarah, is that I'm not aware of any criminal allegations out there.
Got it.
Any pending criminal cases, or even allegations that could result in pending criminal case charges. Right. I'm not aware of that. But the prosecutors tend to be tricky. So, who knows what they have up there.
Yeah. And, Jim and I, like I told you this way back when we first spoke, and Jim and I have the same issue, which is, people call it, a technicality. We got off on a technicality. No, it's not a technicality. It's a procedural deficiency. We work on an honor system to a large extent. We bring our clients forward for specific reason based on specific promises. And that doesn't mean that the next DA who comes in gets to completely gut the promise that was made, basically binding his office because he doesn't like it. So, I mean, that was a great, obviously great work on your part. And it was huge injustice that had to be taken care of.
Yeah, but people don't understand, though, it wasn't just a procedural due process problem. It resulted in a substantive due process problem. Right. Because the jury heard evidence that it never should have heard, that was unreliable. And then we also had an incredible other bad acts type of issue that resulted in the jury hearing, again, evidence that was not reliable. And if you think that doesn't impact a jury's verdict, it does. They heard deposition testimony that should never have been admitted. Right. So it wasn't just the technicality of he never should have been prosecuted. Right. That jury heard evidence that never should have been presented, and had that happen, who knows what the verdict would have been. So
that's why I'm saying procedural efficiency, because it goes to constitutional issues. It's not about a technicality. But people like to think, you had the money, you had a good lawyer, you just got up, you got lucky, all that stuff. Go ahead.
What was that you were going to say, Jim?
Yeah. So Jenny, do I have a case for you? I tried a case for 6 weeks where there was a lot of bad act evidence went in.
But that's the problem with these, as you know, with the Me Too cases, is that it's opened the floodgate. In your case, Jim, it was the financial bad act evidence. But then in our, what Jenny and I typically do, it's like all the women whose statute of limitations bar them from being alleged victims get to come and have their day in court at the expense of the defendant's fair trial. And so, like you, Jenny, I mean, my Me Too practice these days is more putting out the fires before things become really public, and we have to write a check. And I have a problem every time we have to write a check, because we're writing a check essentially for something to go away that may not have happened. Usually it didn't happen. And it's like insurance. And like you and I had talked about, it's a borrowed quote, but essentially that the Me Too began as a movement, then became a business, and now it's a racket. And now add to that, we have look back window laws. So what is a look back window law first? Like, can you define that for us?
Yeah, sure. So a look back window is essentially when a state passes an amendment to a civil statute of limitations and revives a expired statute of limitations, which you can't do in the criminal context because that would violate ex post facto laws. Right. But in civil, the U.S. Supreme Court, in a decision that should be revisited, in my view, said that no, civil cases, we don't have to worry about the ex post facto clause in civil cases. Yeah, and they're not punitive, which, there's a whole punitive damages. Sounds like it's punitive, but in civil cases, and I believe now we're at least at 4 states. I know New York, New Jersey, California, now recently Nevada, they first started by opening up windows for individuals who were victims of child sexual abuse to bring their claims, even though the statute of limitations on those sexual battery claims had expired. So they were being permitted to revive those claims. And there were some decent policy reasons around that, namely, children are children. They can't go to the police themselves. It takes a long time to process. Maybe they don't understand what happened. Again, it all centered around, I still think those statutes are problematic, but just, indulging the policy reasons behind it. Yes, there might be for children some reasons. Now they're saying even
adult.
So you can have you can have an allegation that stems back from the 60s or the 1600s, frankly. It doesn't really matter.
That's a court case I would like to go see.
I mean,
1600s on the stand. Let's do it.
Yeah, nothing. There's nothing that prevents anybody from saying that. I mean, it's an interesting thought because you can always sue an estate, I suppose. So, like, you can have everybody dead, bringing a lasso. But putting that aside, so these look back windows in New York, it's the Adult Survivors Act. Even if you were an adult and something happened to you that is a sexual battery, it has to sort of be based in the criminal penal code. So you have to be able to point to a penal statute that says the offender did this to me. This was
sexual assault.
Yeah, let's just say rape, sexual assault, right?
Right.
You have to point to a penal code violation, but you can bring it as a sexual battery. So you tether it to that tort claim, and you can do it for a period of time, irrespective of when it happened. We don't care.
So I have a question about that. So because I looked at the California law, which says you have until the end of 2025.
Yeah.
Why, if there is a basis in the legislation that they allow alleged victims to come forward with these stale claims, and pretty much, as you know, Jenny, there's all kinds of sexual wrongdoing and misconduct in the code, in the criminal code. So that's like everything. And so if there is a crime equivalent under the penal code, then you can, you're not barred by the civil statute of limitations. But why is it temporary if it's so good?
So I think I'm speculating a little bit, but my understanding is that was maybe the legislature's one way of feeling like they weren't, that they were putting some limitation on it, right? So we're going to open it for a period of time. Last and final call, ladies. If this you have your claim, you can bring it. What I will also point out, though, is that it's not going to be an issue moving forward because most states have just abolished now most states have abolished statutes of limitations for sex crimes that have occurred more recently. What this is designed to get at is those claims from the 60s and 70s and early 80s, where in 80s and even 90s a little bit, where the statutes of limitations were quite short. It was before there was a movement, and frankly, even before people cared.
Before the movement, before.
And so, but once you get into the 2000s, then they started, in late 90s, they started changing the laws anyways to expand these statutes of limitations. So you don't need a look back window, frankly, for some of those claims, because the window never closed in some states for those allegations that occurred a little closer to modern times, if that makes sense. It's really...
But this last call for alcohol or whatever, last call is really unconstitutional. I mean, I think it's got...
I've raised multiple challenges, both California, New Jersey, and New York. And essentially our argument is that it is a violation of due process to revive a expired statute of limitations. How do
you defend that? I mean, listen, Jim was asking me, Jim should ask you, because I don't know the answer, to go over each of Cosby's pending cases with us that right now where he's facing these look back type laws that allow these women to come forward. But how do you defend just generally, what witness do you get out of a grave, or how do you get documents from the Playboy Mansion, for example?
Yeah. So that's a great question. It also goes to the constitutional challenge, which is it's a due process violation because you can't defend it. Yeah. It is not actually possible. So, and I'd like to say this. So right now, Mr. Cosby has a case pending of an adult accuser from California. I think there are 4 or 5 women in New York, 1 in New Jersey, although she actually has 3 lawsuits in 3 different states. Lily Bernard is one of the accusers, and she's filed in 3 different states because she says different incidences happened in 3 different states. So, and then there's 6 or 7 other women from Nevada. So, and they're bringing these almost as class actions now, which is
class action.
Well, they're bringing the plaintiffs are joining together in single lawsuits because they all have the same lawyers. Who has
is it Gloria Allred?
Well, it's not.
It's Lisa Bloom.
It's somebody in New York who it's kind of like those ads. He literally on his website has an ad that says, if you were abused by Bill Cosby, you may be entitled to compensation.
Oh, wow.
Yeah, it's really it's become, a racket.
Yeah.
And I like to joke that all you need is yourself with a picture of a celebrity now from the 1970s.
Wow.
And it's a wrap. It's it. That's all you need.
Jenny, in the Me Too movement, it becomes no longer someone's presumed innocent when they're accused of some sort of sexual misconduct. It's the complete opposite. I mean, it becomes such a hot issue, and that if you challenge the accusation, then you're misogynistic. You're a pig.
It's hard to defend. I almost think men can't even defend it almost because they are going to. I can say stuff that a man can't say, but it's putting that aside. You're absolutely right, Jim, because this is what happens, and I've seen it in real life because I'm probably one of the only people in the country. One of the only people. I mean, I know Trump's lawyers just tried it. One of the only people that has actually taken to trial one of these cases that was brought under a look back window where the allegations stemmed from the mid 70s against Mr. Cosby. And I will say this and that was represented by Allred's firm. And on the eve of trial, she changed the entire year that it happened, entire year. So think about this. If you are particularly a prominent person, there's a good chance you know what you were doing. We can track Mr. Cosby's calendars going back to the 70s because you can look at newspapers and see where he was. There might be gaps here and there. You can see where he was performing. He was very active because he was on the road. He was doing shows. He was. We can recreate his calendar. So that could be potentially very useful, right? Here's the problem. If the plaintiff can't even tell us what year it happened in, we don't even have a potential alibi defense because we can't figure out
where to put him.
We don't even know where to start. And in the case that was tried in California, she claimed an incident happened at the Playboy Mansion. She claimed for about 5 years that it was in 1970. I don't remember, 74. Where she said she was younger. And then it turns out it was actually closer to 76. Like it was. And so when they did discovery, Playboy would only give 1 year of records. They gave the year of records is when the plaintiff said it happened. On the eve of trial, the whole year changes. We go back to Playboy and say, we need those records. They're gone. So
and you have to remember that with the advent of the, just the digital internet, all that stuff, a lot of places transitioned from the old archaic note keeping and record keeping. Well, but I mean, there could be instances where, you just have no access to any documents because they're so old. Who was the plaintiff?
And then I don't know Mr. Cosby's mental health, his physical health, but I mean, after all these years, the defendant, loses memory. I'm not saying a comment on his personal situation, but I would have a hard time remembering what I did 20 years ago.
You know what? It is a real problem because he can't even really, in some ways, give his best defense because he may not, and this is a point he's always made. You're showing, first of all, he's lost his sight. He's unsighted at this point. So you can't even show him a picture now and say, does this jog your memory?
Oh, wow.
Do you know this person? You can't even do that. So you want to tell me that, do you know how many people Bill Cosby has taken a picture with in his lifetime? Do you have any sense of, and he was a very friendly, he was someone who would always take pictures with fans, etc. It is so what ends up in the courtroom is a he said, she said in the most literal sense of the word. No ability to corroborate, zero. No ability to present an affirmative defense. We can't even get a date that this happened. And you have a situation where you have the defendant who is presumed guilty because, not only because he's been tried and, in the media, there's no jury that's not going to know who Bill Cosby is. Plus, these courts are letting in, on top of that, all of this 404B evidence. And then the plaintiff is now, we're in a world where believe women, no matter what. We're not going to, we have now turned it all upside down. We've turned I'm a feminist. I believe that things needed to change. There was a time when women were not believed when they should have been believed, but the pendulum has just swung too far, and it's been done in our courtrooms. Hey, how about we do it in culture first? You guys figure, let's be better human beings and figure out, believe your friend next time she tells you. But what you want to do is what this movement wants to do is right the wrongs of centuries of male misconduct on the back of about 5 dudes
in a court of law
who are very rich in their minds. And there's an stated responsibility on the parts of Bill Cosby, Harvey Weinstein. It's symbolic more than anything. And
well,
to me,
and it's like, what does this movement do for women who are assaulted in similar contexts where there's a power dynamic and whatnot, but the guy is just not as wealthy or rich or well known.
Yeah, I'm sure some lady in an Arkansas restaurant somewhere is being harassed by some boss. I do not see Me Too down there.
Right.
Okay. I just, it's a little.
I know. It's and look, as women, I know you guys can't speak to this, but we certainly can. I'm not a feminist. I'm not gonna lie. I'm not a feminist. I'm just not. But I support any movement that ends, suffocating the voice of any group, gender or whatever based. However, when it comes to violating, when it's the cost to pay for that is the violation of even one person's constitutional rights. That's right.
That's not. I mean, I'm not willing to make that exchange as a criminal defense attorney. There's too much at stake in our system to to start bending the rules because we have so much anger against a group of individuals or people, or really what we're talking about is a whole attitude. Women are really angry about, people are angry about, and that's fine. But you don't bend the rules in our sacred criminal justice process that's cheap.
Yes.
That's only going to end up.
You mentioned Cosby taking pictures with God knows, how many women over the years. I remember.
I don't want to, I'm not just women, but like all types of people.
People, fans. I remember back when Chris Cuomo was at CNN, he said something interesting to me, and this was not actually, somebody had told him to do this. It wasn't an idea he came up with. That when he's out in the Hamptons or wherever he hangs out with on the weekends, and people were coming up to him to take pictures, he said he would always hold out his hand to where you see it in the picture.
That's what it's come to.
It's insane. Wow. I mean, because he didn't want somebody to then take the picture decades later, or not even 2 years later, and say, I took this picture and he was groping me. You know what I mean? I mean, it's just is
absolutely. I mean, it would be actually a crime to do this, but I have a girlfriend who is a famous concert violinist. And she played at the White House when she was 19 years old. And she has this really cool picture of her and Bill Clinton. And it was caught in a moment, and she's quite young. And he's looking at her, and if you know Bill Clinton, he's got quite a personality. And you catch this picture, and you're like, oh, what's going through? You could put a whole story behind it. Whatever you want to put onto that photo based on what's in your brain.
Well, plus he likes them young. Did she have a beret?
I'm not getting into that. But what I will say is, you could take a photo like that, and you could get, with what politics are nowadays, you could make a whole fabricated story. You could bring a lawsuit. You could do anything in this world right now, in this political climate, and a complete fabrication. You could do it. It's not that hard to do.
Yeah.
And
out of context.
President Biden has been on the receiving end of that same criticism.
That terror.
And he is a toucher. He's a hugger. I've been in his presence. He hugged my wife. He didn't really hug me. And, so, that's just.
Was it upsetting? Did you wish that he hugged you too?
I was more offended that my wife was a lot more interested in him than she was in me.
So, okay. Something we've been wanting to ask you is obviously the podcast, we talk about crime and quasi-crime, but we felt strongly about the impact of the media on the presumption of innocence and the right to a fair trial. And Cosby obviously was America's dad, Dr. Huxtable, and then suddenly he has a booking photo, and Matt's doing something. What a juxtaposition, right? And so obviously, look, he's, in his later years, he built a legacy. He had his career, like you said, he worked really hard. But with these accusations, you can't say, even though you turned around that criminal conviction on appeal, This has done a lot of damage to this guy.
No, I mean, it is. That's why I joke when they say, well, the civil suits aren't punitive. I mean, there's been nothing not punitive about this process. And let's not forget that he has not been convicted of anything at this point.
Right.
He's absolutely presumed innocent and is, in fact, innocent of any criminal charges. Like there's nothing out there. There's no conviction. And yet that would come to a shock to the average person that is just, walking down the street and knows a little something. And
as an average person, let me say, I find that shocking. I did not know that. And I feel like I could ask 20 people in my immediate circle and they would all be just as surprised.
Yeah. He has not been convicted of any crime, and he does not stand convicted of any crime.
And yet he's looked upon and he's referred to as like a convicted sex abuser. I mean, let me tell you what was the most eye-opening thing to me when I did some depositions in the civil case. Do you all remember that really powerful New York Magazine cover where all the women, all his accusers sitting in chairs? It was a visual that was like no other, right? And I had the interesting experience of deposing some of those women as part of the civil lawsuit. And I asked them about what that was like. And they're like, I said, so did you sit for an interview with a journalist? No. So what did they come? I mean, how did it come to be? Oh, we just were told to show up at a warehouse and wear a certain thing. And we got our picture taken. Got our makeup done.
Got our makeup
did.
Sat down. Maybe there were a couple sentences of a blurb we wrote out or some press release that Gloria sent them. And that was the journalistic investigation that was done by New York Magazine. It was all smoke and mirrors and show or a visual. And really the message is, how could all these women be lying? That's all it was. And it's like, you know what though? All I can tell you is I take one case at a time, but that's not evidence. That is just a powerful image. It's propaganda is what it is. You're taking one powerful image to try to over-influence people without any substance behind it. And
look, they say it's they say in this context where there's so many women describing similar pattern of conduct, there's a power in numbers, and to that I call that collusion, because when you're dealing with if you're dealing with in no name cases where the client is your average neighbor or whatever. When there's a connection between these accusers, right? I always call it collusion because one person tells the story, then the other ones adopt it, that kind of. When you're dealing with a high-profile guy, it's enough for one person's accusations to come out about how she was drugged and then she woke up the next day, and then they're all saying the same thing.
Yeah, it's interesting that there was just this incredible onslaught of very similar allegations at the exact same time.
Yeah.
Right.
You're telling me not one person had the courage to report this at the time it happened? Yeah. I get it. Yeah, they'll all say, oh, he was so powerful. He was that. Okay. There are so many of you, though. You're telling me that not a one was able to muster up the courage.
But I also have a problem. This is something the guys can't say, but we can say. I also have a real problem with the idea that you have a point about, not one of you had the courage is, it kind of raises an eyebrow. The other thing that raises an eyebrow is this idea that I consented, but because of the power, because I felt like this might happen to me, because I felt there was a judge here in LA County who my friend took Trevor Bauer's, the Dodger player's restraining order, she was defending it before this family law judge. It was a restraining order, so it was not criminal or not whatnot. And there was extensive text messaging between the accuser and Trevor Bauer about what she wanted done to her. This was like a rough sex scenario. Mm-hmm. And she then later said, buyer's remorse, right? She said she was assaulted and violated and smacked and all this stuff. Well, the judge in that case, I love this judge. She said, she like wears these like little pill hats and stuff, anyway, she said, well, if no means no, then yes means yes. And I thought, this is so brilliant, because the girl was essentially saying, I said, yeah. I mean, yeah, she was confronted with all the messages. So,
I guess I think what they would say, and I'm not, I think text evidence can be very helpful. I mean, I think it made Chris Brown's allegations go away.
Right.
Obviously I do think a woman can change her mind.
Sure.
So I'm not against that idea. But I do think, those text messages are very helpful, because we do see it's not just women making things up out of whole cloth. Oh, that does happen. It absolutely does. But it is also women who are reshaping and reframing an experience that they now look back 20 years later and say,
and they regret.
You regret it, but more than you regret it, you are being told that what happened to you
is assault.
Was assault. Mm-hmm. And you say, I really didn't enjoy it. I mean, anybody could do it. It's not that hard to look back, particularly as a woman, and and I'm sure men can do the same thing in different ways, but
men do it the next morning.
I look back from experiences from my teens and say, I don't know.
Men are basic, Jenny. Men are basic. They do it the next morning.
I tell you, Matt, just a little sage advice I learned a long time ago when topics like these. There's a saying that silence is a friend that will never betray you. So that's why Matt and I are sitting here.
Yep.
Mom's the word from us. No, yes means yes, maybe, who knows.
But what I'm saying is, like this Trevor Bauer thing, just real quick. The girl was driving from San Diego to Pasadena, which, if I was going to estimate, it's almost a 3-hour drive. Okay. And during this drive, she was texting about what she wants done to her. So clearly there was consent, but then she was essentially in court. Yeah. Essentially in court, she was saying, well, the reason I consented is because I believed I needed to please him. And it's like,
I mean, there is a whole school of thought there. And it's coming to this point that, we're even seeing it with this, whatever. There's so many examples of it, but yes, let me put it in concrete terms. In the Cosby trial, we put on 2 expert witnesses. One of them is Beth Loftus, who is one of the most famous memory experts, one of the most famous and prolific and accomplished scholar in the world, and did the groundbreaking work about identification evidence, but also memory, right? Mm-hmm. And also Dr. Debbie Davis, who does similar types of work, but she talks about this whole concept of unwanted consensual sex. Okay. Mm-hmm. And there's a school of thought that unwanted sex is unconsensual sex. And I'm going to show you about 90% of the population of wives out in Long Island that will tell you otherwise, but no, of course there is even men, unwanted consensual sex. You're doing it for some other reason maybe, but it's still consensual, right? Yeah. And we had an expert, it was the plaintiff's expert during the Huth trial who tried to say that consent is just really all in the woman's mind. And I have to say, I got to hand it to Judge Carlin, who was a great judge on this issue. There's things I did disagree with him on, but he was really good on this particular issue. He said, no, wait a second. The state of mind of the defendant does matter in a court of law when for criminal cases and civil cases, ma'am. Right. You don't define consent in the context of whatever a therapeutic setting is, or a psychologist, or whatever the American medical. That is the problem. We're conflating standards now. in a court of law that even consent, which is a legal concept, and it's all about the male state of mind or the accused state of mind. What did he intend? And also there's an element of whether it was reasonable to believe.
Right. I mean, an objective person would believe it or not. Yeah.
You know, there's that piece of it. But she was turning it all upside. No, it doesn't matter what he thinks. It just matters what her experience was. Well, geez. Yeah. That we're all in trouble. Every last one of us is in trouble.
So basically, the men basically have to have a crystal ball.
Right, exactly. You better hope someone does not have a change of heart. And with these look back windows, so you can have a change of heart 100 years later and you're still getting sued. And it's going to. So, I mean, you know, I'm being hyperbolic a little bit, but not too much.
So I want to end with Jim. Go ahead. Because
I have 2 points before we close. One,
be careful. Jenny, don't mansplain too hard here.
No,
Jim.
I don't mind. I don't mind.
Don't you worry.
All right. I just, you gave me some advice. I'm just pushing it right back.
I'm going to the law. Law is a jealous mistress.
Oh, you have good news, Jen.
I know. I'm trying to get there, Jenny. My daughter's a lawyer in Boulder, Colorado, and her law firm handled a case on behalf of the school district out there, Aora School District, and challenged the look-back law. And on June 23rd, a few weeks ago, the Colorado Supreme Court ruled that it violated the state constitution's prohibition against ex post facto civil laws. And so,
interesting.
And, so very proud of my daughter, Hope. And I think we got a father-daughter photo out there that we met. Yeah, I want to show that.
Well, that's quite an accomplishment.
Well, all I see is your
big
and
I are on top of the world. Not really, but Gray's Peak in Colorado.
And a dog. And Hope way back there.
I'm about to get oxygen therapy right there, and we're just having a great old time. So,
you know, that's great. And you know, Jim, there are some states that have it enshrined in their state constitutions. You cannot, like Illinois. They have some good law, and it's based in state constitution. You can't revive a expired statute of limitations. And here you're giving an example of where a state had ex post facto prohibitions in their state constitution. So that's where it's going to be hard for those state legislatures to do what other state legislatures have been able to do. But that's very good.
So I want to close with
one more point I just want to throw out. I remember very well in 1991, the state of South Carolina got hammered by Hurricane Hugo, wiped out Charleston, wiped out the South Carolina coast, and we were all traumatized. And Bill Cosby came to Columbia, South Carolina, and gave a benefit concert, or he was stage presence. He didn't charge anybody, and all the money went to that they collected. It was all volunteer contributions, went to the relief fund, and he came in, he left, and I know I was there.
Yeah,
he's done a lot of good. He has really done a lot of good.
Yeah, I think it's very sad. As criminal defense attorneys, we believe in the concept of, people. There are whole human beings here. Okay. I think it's good to remember. I think it's good for this mob justice mentality that we just live in a world where we're villainizing people, painting them, good, bad, and people are complex. There's people can still do good, and you can still really disagree or think that they have done bad in this other way, but. Man, I don't. I think we have the ability to understand that, because we have clients sometimes, and I'm not talking about Mr. Cosby here, but you have clients who sometimes we have clients who have done things, and we need to. But still, our job is to make sure that the system still treats them fairly. Where we don't. This isn't China, This isn't some horrific place,
third world country or something.
Yeah, where they just string.
I was talking about this with a colleague of mine who just surprisingly his client pled. It was that Cementilli murder case. It's a love triangle here in LA. The wife is going to go to trial, and he was saying, people they can't understand that when you're sitting, they say, oh, he's a criminal. He's committed this heinous slaying or whatever. And when we deal with our clients, they're just they're just regular guys. I mean, mostly guys, but they're just a regular person, and so it's rare that you have, a serial killer or like, somebody with that kind of criminal mind. And so it's hard for people to understand. I want you to react to 2 tweets that I found. I'm not going to out the handle, but it really pissed me the fuck off because we can cuss on this podcast. Matt, what were the tweets? There were 2 tweets.
Yep, going up right now here. The first one says the Bryan Kohberger defense just hired 2 additional DNA consultants from out of state. Becca Barlow from California, Stephen B. Mercer from Maryland. This will cost the Idaho taxpayers hundreds of thousands. And if you'd like, I'll read the next one.
Yeah, please.
Bryan Kohberger defense has a blank check to hire experts. Latah County commissioners have not put it in check. Most likely hundreds of thousands already spent. Expect them to hire more experts at the taxpayers' expense.
So, the reason I brought these 2 up is because this was part of this thread of public defender bashing. And I know that you started your career as a public defender. I have great respect for public defenders as attorneys, both in the office and after they leave the office. And I know why there are limitations on resources and things where people don't think they, can get what they can get from a private attorney. But public defenders sometimes are by far better than private attorneys who sometimes are just after money. And so what is your reaction to this criticism about how much Bryan Kohberger's public defender is getting in Idaho? Or how much?
The first question is, are the people of the state of Idaho trying to kill Bryan Kohberger?
Exactly.
Pretty much.
Are you trying to kill him? I think you're trying to kill him. So I'm going to say that perhaps if you want to support a death penalty statute, taxpayers of the state of Idaho, you better buckle up for some big bills because it's very expensive to kill people, as it should be. As it should be. It should be very expensive to kill people. Why? Because we should afford every available due process and every available resource to people that the state is trying to kill. Again, unless you like China's system or other systems, I think that this is the bare minimum. Now, I am not a proponent of the death penalty, as you all can probably imagine. But so the other thing I have to say is this is not these tweets fail to recognize what the real problem is. The real problem is the opposite of what they're complaining about. The real problem is that public defenders don't have the resources. Yeah. They are getting the resources in this incredibly high profile case because all eyes are on them. And again, they're trying to kill him. The bigger problem is that they're not getting resources for your average run-of-the-mill murder that might benefit from some DNA expert or fingerprint evidence or some things that they're cutting corners on. So as far as I'm concerned, y'all have had a break. Like there's no absolute way that taxpayers have gotten anything but a gift from their local public defender's office. And it's the bare minimum we can expect. Let these people do their job. Yeah. And then maybe if he is convicted, the state will have a much better time defending that conviction all the way up, because if it's a death penalty case, it's going to be going up all the way up to the U.S. Supreme Court at some point.
And what's that going to cost? I mean that's the whole thing. That's the whole thing. They don't realize that the challenges that we point out. I've been very vocal on this Kohberger thing, and I've lured Jim into that thread too. But the challenges or the critical thinking that I'm trying to sort of trigger in people that are open to it is because I'm just trying to say, look, both sides want a fair trial, because if he gets convicted and there are issues, like you said, then no prosecutor wants that, because they're going to have years of appellate fights and it's going to cost the state. So
yeah, that's what I say. For any taxpayer that's worried about that, if you want it done right the first time, give the man all the resources he can get. Right. And if there's a verdict and there's a death penalty decision, then you probably it's probably going to save money in the long run, frankly. Wow. I mean, but that's just the economic practical sense. There's also just the fairness piece of this that I can guarantee you, whatever the public defender's spending, it ain't a fraction of what the government or the state is spending to prosecute this case.
One last thing. Jim and I were talking about the Menendez brothers and how they have petitioned the court for leave to file a writ of habeas corpus. Obviously, that's your forte. And what I found interesting is this case were 2 trials. The first was hung. The second one was a conviction. And in the second one, what was missing is the evidence of essentially the prosecution argued to the jury, don't buy the abuse excuse. I mean, I can't even, we're talking about Cosby and these women. I mean, I can't even imagine anybody arguing that today. So it's a nice juxtaposition. What do you think? Do you think they're going to walk out? Do you think they're going to get relief?
So I don't know enough about the details of that case.
Yeah.
What I will say is that if there was evidence that existed about abuse, which I believe there is now pretty strong corroboration that it wasn't just some fabricated, scheme to, but obviously there's still a hurdle as it relates to whether there was some imminent fear on the part of them at the time that the killing happened or the crime happened. But do I think there's something there? It sure seems like there's new evidence and there's a more of an appetite to on the part of the courts and just people generally to recognize that this type of abuse happens. But
so what does he need to show? What do they need to show? So 2 things I want to say. In the first trial where it was hung, what they were allowed to present was, the brothers testified about the abuse. Could be self-serving, and then some family members, but nobody, no simultaneous, statements about the abuse, no precipient witnesses, obviously, but the second trial, none of that. So now there is a letter that one of the brothers had written his cousin very close to a time where the father was walking in and he was expressing distress and said, I hope he doesn't come in the room. I fear that he's, I basically was alluding to the abuse. And then there's the Menudo band member who claims that he was sodomized by Menendez Sr. So it's pretty substantial evidence. But on a writ of habeas corpus, what does someone need to show to be able to walk out of prison?
Well, is this being raised in state court or federal court?
State court.
So California state court habeas corpus rules is not necessarily my expertise. Federal habeas corpus would be more my expertise. But what I can say is I do a ton of post-conviction work in a number of states, not California, not part of California, actually. All of my work there has been pro hoc. I should be barred there because it does seem, it's just something I have some clients that are going to need me there. But, typically the burden is very, very high on, really in any post-conviction type of statutes. In federal court, it's almost impossible to meet. There are so many procedural hurdles and timeliness requirements. And I'm sure the state writ of habeas corpus statute in California has a similarly high standard. My guess is they will have to show that the evidence was unavailable, somehow was not available back then, or that somehow the law has changed in a way that makes this admissible in not that the judge got it wrong the first time, because if the judge just got it wrong, then that would be a direct appeal issue. It's something but if you can point to the law having changed and say, okay, maybe under the law that existed at the time, he was right, but now the law has changed and we really should. And then there becomes a question of whether it should retroactively apply, blah, blah, blah. But I think, their biggest hurdle is to show, that this is actually new evidence. It wasn't previously available. These witnesses weren't cooperative, or maybe the letter
Or they didn't have the letter. They didn't have the letter. So they lay all that out. But my question is what
is that enough in terms of I don't know. I don't know what the other independent evidence was. And the question is, as a legal matter, you would have to, I guess there's a debate about whether, depending on the timing of it, right? So if I'm saying, my husband's abusing me and I fear for my life, okay, I am going to, while he's sleeping, go shoot him in the head while he's sleeping because I fear for my life. Yeah. That's a harder call than my husband's coming at me with a knife.
Of course.
And
but it's analogous to the battered women's syndrome defense. We have a very, very liberal DA. I mean, they've tried to remove him. The DAs internally hate him. I supported him and I still support him. But what if the DA here says, I think there was an injustice here? Yeah. Does that help?
Oh, yeah. A lot of states have these conviction integrity units. Yeah. Where they say, and it's not just, it is normally about, is someone actually innocent, but it can also be about, was an injustice committed? And, they can voluntarily go before a court and say, we believe an injustice was committed. Maybe we believe that, there should have been a conviction to a lesser charge or, something, more like a voluntary manslaughter versus, or, whatever. Yes, that can help. And DAs do it. Good DAs do it.
So I want to leave with this. I have tattoos. They're not visible. You have tattoos. Your tattoos are way better than my tattoos. Can you show us the prison tattoo?
Oh, that one. Everyone always wants to see my not guilty tattoo.
Oh, not guilty also, but the one that the client.
Yeah, this is a great little story. I like sharing it. I have I represented a guy who was wrongfully convicted. I was representing him. I would think it was 2012-ish. He was arrested in 1993, so he was going on 20 years. And we had a hearing in front of a trial judge who was not a very good trial judge, and she denied relief in a hearing where we thought we had plainly demonstrated actual innocence. He should be released, et cetera. I was very upset. So sort of in my own act of protest, I tattooed myself. And I have a Homer quote here that says, "Evil deeds do not prosper. The slow man catches up with the swift." All right. Mm-hmm. And then I had his arrest date tattooed. And then I said, when he gets out, I'm going to put his out date. I'm going to get him out. And I left it blank. Well, fast forward.
He got out.
4 years. I got him out. And he got the same tattoo. So we have matching tattoos. Nice. He was able to finish it. So he had his arrest date and his out date, which by the way was July 20th, 2016. I had not finished my tattoo.
What?
I had not done it, but here's the story. We were all hanging out one night up at my country house, a big group of us, some of my clients that I had gotten exonerated. And my associate at the time, Ashley, said, you should have Armando, that's my client's name, tattoo the out date on you. And I was like, yes. So we got like a prison stick and poke, and he tattooed the out date for me on there. So people are like, wow, that doesn't look like the other, but nope, he did it himself with a stick and poke. So I got a real tattoo by.
But y'all got drunk though, right? Y'all got drunk before that.
Well,
happened.
We did have some cocktails in the process. But yeah.
It's amazing.
Like a very meaningful tattoo.
It is. And you are a meaningful friend and colleague. You do great work. And I'm so grateful to you. I had to chase you, girl. I had to chase you. But I got you. So I appreciate you joining us. And I'll see you soon when I come out to New York.
Yeah. And Jim, I don't know, but I actually did a CNN hit on your case, which I don't typically do. I really am not, unlike Sara, I don't love the talking head stuff, but, and I don't know that I'm particularly good at it, but I did do it. And I was very, very, very bothered always by the motive. I just can't shake it.
Right.
I can't shake it.
It's crazy.
So
As we learn in their reply, motive is not an element, and so never mind. After two weeks of financial crimes, never mind.
No, it's not. But I'll tell you this: the prosecution knows they need one.
No. Well, they
didn't have one. So.
That's why they'll make it up, though. Is my point? They'll come up with some crazy idea of some motive, and that It's,
and so they're appealing, and fingers crossed. So we'll see.
Yeah, well, good luck with that.
Well, thanks, Jenny. This has been enjoyed meeting you.
Likewise.
Bill Cosby got an excellent lawyer, and
so much.
Now I know why.
Well, I appreciate that. Appreciate you all having me. Matt, pleasure to meet you.
Thank you so much. Yeah, it was great to have you on. And guys want to officially wrap this all up here?
Yes, and so until next week, Jim, we're going to
rest.